Hi, everybody. Thanks so much for tuning in today. We are officially starting. You have on the call today Charlotte Rafis and Amina Porikanen. We are attorneys with Porikanen Law, and we thought this was a very timely and personally interesting topic. Charlotte and I spend quite a lot of time doing transactions in the home care space in New York. And as you will see from today's presentation, there are a number of things that are easily transferable to transactions in other states. The home care industry is as entrepreneurial as the Silicon Valley. And so many of you do expand into other states, into other lines of services and revenue in the community space, community services, Medicaid, Medicare, other states. So you will see that a number of the things we will be talking about strictly from a corporate standpoint can be transferred into transactions you're contemplating or potentially will be doing in other states. Transfers, however, that are going to be unique to New York, which is what we're focusing on today. However, each state has their own regulatory framework under which they sell healthcare companies, to be referred to broadly. And if we can go to the next slide. So as Charlotte is moving the slides, I want to just go through a couple of housekeeping items. A number of you on the call are clients, and we really appreciate you tuning in today, but a number of you are not. Regardless of whether you are a client or not, nothing we say today should be construed as attorney-client advice on your particular matter. This is strictly for informational purposes, and nothing we say here is confidential. So we welcome your questions in the chat, but some of these may be publicly viewable. So please do not disclose anything you're not comfortable sharing with the rest of the attendees if you do pose a question in the chat. We will take questions at the end, but feel free to put them in the chat as we're going through this and as they come up in your mind as we're covering some of these topics. Now, you will also see that this is quite a comprehensive topic. We have tried to be intentional in what topics we're going to talk about, but there is quite a lot. So we do think that today's program is going to be highly valuable to you and that you will learn a lot about these transactions. But to the extent that there are specific or open issues, please send us an email afterwards and we can certainly pick them up in round 2 of this topic. Okay, let's go over our agenda for today's webinar and then jump into the content. So why are we doing this webinar now? We're waiting for the budget, right? A lot of you are Medicaid billing agencies, and your financial survival is a big question mark. The industry has gone through quite a lot of changes with the elimination of the fiscal intermediary program and conversion to a single statewide FI. So we saw a lot of transactions during last year's scrimmage and fight for survival. But that activity continues to still very much be present. There are a number of FIs, as you know, who have gotten into the home care and Medicaid space for the first time ever through that particular program. It is very difficult for them to just let go of all of the patient relationships that they have developed through that program. And so many of them have found a different landing spot. Many of them have done so through Alexa, where legally permissible to do that. A number of them have unlawfully converted family members into PCA and HHA caregivers. And, we just wait to see when the next indictment or attorney general or Omega investigation will hit. But there are a number of those providers as well. Others have, even before the FI program went through a change. Others have expanded into other lines of service, and so they have found the ability to use the LHCSA or the FI as a jumping off point for other Medicaid community-based services. And so there are a lot of transactions and services that are slightly different than the traditional LHCSA service that are still happening. So there are also a lot of transactions that we're handling because the current reimbursement structure continues to be more and more challenging. And if the LHCSA is solely relying on that line of service to survive, the margins are non-existent. Profit margins are non-existent unless the LHCSA is doing something, cutting corners somewhere, right? To be clear. So that's another reason why there are many transactions happening that we're involved in. Um, but because there is so much activity happening on the corporate side, we are also seeing quite a lot of liabilities that buyers, sellers are inheriting along the way, and we're not sure that they can always appreciate kind of what they're stepping into in this entrepreneurial uh, spirit that they're pursuing. And so we thought it would be wise to have a webinar to at least start a one-on-one conversation about some of these corporate considerations that buyers and sellers need to be aware of. So today we'll talk about the process kind of from the beginning, starting with the term sheet and the letter of intent. Usually that is the kicking off point for a formal transactions. Of course, there's a lot of conversations before parties ever get to that point, and we'll talk about that as well. We'll talk about the very basic structure of a purchase agreement, and that will depend on what the structure of the deal is, what the structure of the buyer or seller entity is. We will touch a little bit on the accounting aspects of what structure, each structure means and the implication it carries. We will talk about some of the key terms that need to be considered in a transaction. And then Charlotte will talk about the regulatory piece. So some of you are either in the process or maybe considering an expansion or an acquisition. A lot of you who have licenses already are in one region, and as Charlotte will talk about, really the best way for you to expand your geographic footprint in New York State is to acquire a licensed home care services agency, and the DOH is not giving out new licenses. So acquisition is really practically and most cost efficiently the only way that you can get into a new territory these days. So Charlotte will talk a little bit about what that process looks like from a regulatory standpoint. And then we will try to reserve time in the end for Q&A. As I said, if there are things that we don't get to, if there are questions that we don't get to, please email us separately. Our contact information will be on the last slide, and we will gladly speak with you then. Okay, Charlotte, next slide, please. Okay, first, I probably get this question once a week at least. I'm looking to buy or I'm looking to sell. Can you help me find a buyer or a seller? So, what comes up in that context? Where do you even find an agency? It's not like there is a listing of everybody that is possibly for sale. Theoretically, anybody can be for sale, correct? Even if there was a listing. So there are brokers who maintain listings and they make them publicly available. But there are a lot of deals that originate based on relationships, who you know in the industry. There are a lot of companies who have a person whose full-time job is strictly to look for new markets, new opportunities, and to look for sellers. And that's how a lot of agencies grew. They had someone in-house whose job was strictly to go around looking for agencies who might be willing to sell. There is a listing of all of the registered LHCSAs in New York State on the DOH website. The status of those agencies is a question mark, and that remains your due diligence as a potential buyer to investigate whether those are smart purchases. And we'll talk a little bit about that. But there is technically a listing. And if you had a full-time person whose job was to just look for a target licks, if that is all to acquire, are calling up. You could knock on doors, moreover, and ask people if they're willing to sell their agency, if they are willing to retire, if they're considering retiring. Um, it is not uncommon for the owner to become ill and for a family to effectively inherit the LHCSA, although that word is a bit of no immediate of the licks to go through. There are all sorts of situations why someone would be willing to sell. And so for very motivated buyers, there's certainly a way to identify who those agencies are without going to a broker and without there being an official listing of everybody for who is on sale. So like I said, at least once a week question, where can I find an agency for sale? And I just gave you the answer. You have to be a little bit resourceful about identifying those agencies that might be willing to sell. And then if they say, well, maybe in a year, maybe not today, but in a year, it is up to you to follow up with them, continue that relationship. Because as they said, it might not be the right time now, but it might be the right time in the future. So, if you wanted to use a broker instead, you know, there's a few question marks. First of all, you don't have to use a broker. A lot of them will offer all sorts of services in order to entice someone to retain them. They can be a buyer broker or a seller broker, but you always have to clarify, and I do highly recommend that you have a contract with them, what side they represent, because they are not regulated. They do not have an ethical code of conduct that they have to follow in order to hold themselves out as a broker. So they can tell you that they're a broker and that they have done 1,000 deals. Nobody can actually call them out on something like that and take away their quote license, because there is no license for them to help broker a transaction. So oftentimes in home care, there's a broker that will represent both the buyer and the seller. There are very strict ethical rules for attorneys, and perhaps that is the framework from which I'm coming. But I am very uncomfortable with a broker representing both sides. And if you imagine yourself in either the buyer or the seller position, you could see some very basic reasons why that wouldn't work, why the broker would be conflicted out, right? He's getting information about the seller and feeding it to the buyer. If the seller says to the broker, well, we do have this lawsuit, but we're hoping to settle it and don't tell anybody, there is nothing stopping the broker from going and telling the buyer. And then the buyer will use that information to renegotiate the price or whatever else the buyer might do. But that is just one of many potential examples where the broker could do a disservice to one side because they're trying to get the deal to close, and yet they have no legal restrictions prohibiting them from playing both sides against the other in their pecuniary interest. So be very, very careful if you do choose to use a broker to identify, are they your broker? And then who is paying their fees? Because there are certainly brokers who will collect a fee from both sides. That's also unethical to me. And that is also a reason why, even if they say they are your broker, but they have an agreement to be paid by both sides, they are effectively representing both sides. And so you don't have that level of trust, confidence, and loyalty if they are in fact working for both sides. So be very careful when you are selecting a broker. You need to ask these questions. We have been in a number of situations where things have gone awry with the broker. You need to have absolutely a written agreement with them spelling these terms out, because I have been at the closing table and the question comes up with who's paying the broker. And by that point, it's been months and months of negotiations about the deal. The broker, hasn't really been involved because they brought the parties to the table, but they show up at the end to get paid. And then they're telling the lawyer that they're going to sue. They're going to sue this party, that party, if they don't get paid. And then the question is, well, okay, fine, they can be paid out of the proceeds of the transaction, but out of whose, right? Is it the seller's proceeds? Because the seller thought the broker was the buyer's broker. And so it is advisable to have this in writing and decided at the very beginning. Okay, who are they actually representing? And then do you need to use them? Well, the fees that they charge, first of all, there is a fee. And like I said, they may charge both sides a fee. But what are they doing for that fee? And what is the range of the fee? I've seen all sorts of fees. I've seen fees as high as 40% for a broker. I've seen some as low as 10% um, of the sales price, right? So immediately, if it's tied to the sales price, they have an interest to increase the sales price. Keep that in mind. What does that actually mean for you as a seller with a who has a broker? Well, it may be really hard and long before you find a buyer because that price is inflated due to the broker's interest in their fees. So just keep that in mind when you're negotiating with the broker about how they will be paid. You could have a scale, right? You could have an initial price and then have a scale as well so that their uh, um, fee does go up if the transaction should be negotiated for much, much higher. So there's all sorts of ways to get around this, but keep in mind everything is negotiable. There's no magic broker that I have come across in almost 20 years of doing this. They have a certain role and a value to play in smoothing out conversations and getting the parties to a table, but there's no reason to pay a premium such as a 40% finder's fee, especially when this information is in the public domain. And with some due diligence and dedication and a very convincing salesperson, you could bring the parties to the table um, other ways. So think very carefully before you commit to a broker and to any terms. The other point I want to mention here, you have to make sure you sign a confidentiality agreement with them. They will receive all sorts of information about your agency. You have to be careful how you give them that information. Is it on a Gmail account that is not secure, right? They could easily be hacked. A lot of brokers are solo. They do not work in an actual office that has actual procedures for security, against breaches. They don't even have a cybersecurity policy. They may not even have a general liability policy. What is stopping them from taking your entire patient list, your rates, etc., everything you give them about your company in order for them to find you a buyer? What is stopping them, unless you have a contract, from sharing that information? What is to stop them from using that to extort you to hire them or keep them hired? Be careful. And this goes for brokers and really everybody else with who you share your information with. The only thing that protects you is a written agreement, not a handshake, not a common friend, not even a bloodline, right? Not a common place of worship. Because those can be litigated as well. Maybe they go to a rabbi instead of an arbitrator, but there are all sorts of breaches and violations that could happen. You've spent years building this business. Before you disclose any information to a broker or any third party about your business, make sure you do some due diligence on who they are, whether they are ethical, whether they are just commonly decent and honest, and then make sure that they are bound to a contractual obligation to maintain your confidentiality, and to protect your assets and information that you share with them. Now, next, when to involve counsel. This is also a common question that we get. Counsel typically will not serve as a broker because our firm, and I'm sure other attorneys as well, work with a lot of businesses. We often get asked, "Can find me a business? Maybe I have some money, right? Find me a business I want to buy," or "Can you find me someone and help broker it?" Attorneys will typically not get involved at this stage of getting parties to a table. They will typically become involved when there's a contract to prepare, review, and advise you about. And as I said, you really need to have a written contract with your broker. So if your first step in the transaction world is to get a broker to find you a buyer, um, then or to find you a seller, then the attorney becomes involved when you need that contract prepared. A lot of brokers, by the way, use their own template agreements. This is before AI, but I saw one once. It was horrible. It was like a single page agreement. And I'm like, given all of these issues that I have just reviewed with you all on this webinar, How do you possibly put all of that in a single page? One side. You don't. And so be careful with the template documents that the brokers may give you to sign, retaining them. And by the way, if it's not a broker, if it's a consultant or someone who calls themselves a consultant, it doesn't matter. Those titles do not matter. They are a third party. They have no obligation to maintain your confidential information unless you contractually bind them. Okay, so whatever their title, whether it's a broker, a business consultant, advisor, et cetera, there's no privilege, there's no legal obligation of confidentiality unless you put them under a contract. Lastly, on this slide, there's no attorney-client privilege with a broker. So, assuming they have been retained, they signed an NDA. The NDA still doesn't create privilege, just to be clear. So the best NDA in the world with a broker will not prohibit that broker from testifying against you. Do not admit to the broker, we have a captive. We have an offshore captive, right? We have an investigation with the AG that's been pending for years. We don't know if anything's going to come of it. We're a little bit concerned about it, et cetera, et cetera, et cetera. Okay. That is not discussed with the broker. That is discussed with your attorney under privilege. And I often have clients who want to bring the broker in on calls that I have with them, but I explain to them that privilege is sacred. If the broker comes in to discuss what we're talking about, that privilege is gone. And so, respectfully to your broker, your friend, whoever it is, they cannot be part of these conversations that we have as attorney-client. All right, next slide, please. Okay, so you have found someone who is interested in buying your agency because you're ready to retire, or you are the buyer and you want to memorialize the handshake or verbal agreement that you have. We suggest that you have a letter of intent or a term sheet. It is not legally required that you have this, but I will tell you a handshake deal, a verbal agreement, a napkin agreement, those go away very quickly. All right. Put things in writing, have them reviewed by counsel. We have done so many of these. It's a 2-hour conversation and a job to go through everything with you. I cannot tell you how many times we call someone. We have a call with someone who very casually says, we agreed to sell our agency for this much. These are the terms, write it up. And they expect it to be a 5-minute job. And then we start asking questions. And then they realize, oh, I haven't thought about the tax issues. Oh, I haven't thought about the fact that they might want a price reduction once they do some due diligence. Oh, I didn't realize that they have no cases at all on their LHCSA. And so I'm buying something that I might not actually be able to take ownership of. So there's all of these things that really need to be considered. And at most, though, it's a 2-hour commitment to actually get this due diligence right before you waste months and months of time pursuing something that may not be worth your while. So the LOI is typically the first formal document signed by the buyer and seller. It doesn't matter who prepares it, whether it comes from the buyer's counsel or the seller's counsel. It can come from either side. Many brokers will have their own template LOIs, but do not use that form. Again, just like everything stated, by a broker, even a very loyal one, I've seen a lot of these that come to us from our clients that the broker gave them and filled in some details, and they're still not properly drafted. And I'll explain why it is important to have a good, properly drafted LOI or term sheet. So the LOI should definitely be done under the advice of counsel because the attorney will advise you about regulatory issues as well. Not just the corporate structure, not just accounting considerations you have depending on how your entity is structured. Some of the questions we ask, well, who's the buyer? We're talking to people, obviously, but the buyer might be an entity depending on what the target looks like. So it might not be a live person. Oh, I have a silent partner. Okay. Well, if it's a licensed entity, that partner may have to be disclosed at some point. Well, they're just the money person, right? So we've heard it all. And it's amazing how many of these do actually happen, these transactions that are not really buttoned up, how many of them actually do happen. But then eventually at some point, things do kind of go awry. Um, then there's a question about there's a deposit. So uh, whoever is selling the agency, as a condition of taking their agency off the market and not having it available to the rest of the world and to other buyers, they may demand that the potential buyer pays a deposit. Now, then the question becomes whether that deposit is refundable and under what conditions. Most terms in the LOI are non-binding, which means this is just our tentative agreement, high level of what we've agreed to. But there are some things that should be binding, and we'll talk about that. If a term is binding, then the LOI must say that. And that's important. You don't want to leave this to be ambiguous, what's binding and what's not. Ambiguities become lawsuits. So be careful about saying something in the LOI that binds you to close on the deal. The LOI is too premature of a point in the party's deal to bind you to that. And the definition of what means to close on LHCSA needs to be negotiated. Unlike other businesses that you buy, the closing happens years later after the DOH authorizes a change of ownership. The closing does not happen when the purchase agreements are signed. So that definition of the closing is important because a lot of obligations flow from either the date that you signed or the date that you closed. But the LOI is just a starting point, okay? It is a term sheet. Think of it seriously as a more formal napkin handshake agreement that does clearly say what terms are binding and what terms are enforceable. They have the effect and force of a contract. Other terms that are not binding, they are subject to change. Later on, when you do due diligence, they can be changed. All right. Next slide, please. Okay. So what's binding or non-binding really depends on the party's agreement. But generally speaking, non-binding items are typically the purchase price. So the seller and the buyer may agree, let's just say $1 million for the purchase price. But if the due diligence or something later in the parties, you have the right to change the price. You are not locked in, especially if you've very clearly said only these terms are binding in the LOI. If you say that this is the price, it's binding and there is no change, and then later you try to back out of the deal or try to change the price, made some representation, you could be sued. Okay. You could be sued by the other side who says, no, 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 the LOI says a term that is binding. So this one cannot be changed. You need to sell or buy the agency for this number. So again, that's why it's important to be very clear what is effectively a contractual term in the LOI and what is not. Closing conditions. Those are going to be either binding or non-binding. Typically, they're non-binding because at the time of the LOI, you have no idea of all of the conditions that you might need in order to close. For all you know, the DOH may change the regulatory structure and require something else in order to close on the deal. So for something like this, you need to leave yourself wiggle room for the benefit of both sides so that you can update the closing conditions. At the same time, you do not want to leave that entirely open-ended because then either side could add something pretty expensive at the very end as you're getting ready to finish this up. Representations and warranties, they are typically non-binding in an LOI, but absolutely binding in the actual purchase agreement. What is typically binding in an LOI is the confidentiality provision and the deposit, whether the deposit, if there is one, is refundable or not. And then the confidentiality term, what I typically see is a skinny confidentiality term in the LOI. And then I really like to have the parties do a much more comprehensive NDA before the due diligence kicks off. And that's where we cover things like, how is this information going to be exchanged? Is it going to be secure? Who has access to it? What happens with this information if the deal doesn't go through? I mean, in this day and age, with what someone can do with your data, they can effectively use AI to replicate your entire business model if they have enough information. You really want to spend the time to protect that if you're going to be exchanging it for 3 months or 60 days, however long, to negotiate the deal. Next page, please. I gotta speed up a little bit. I'm so Charlotte has enough time. All right, exclusivity period. I want to talk a little bit about this because it's very important. The exclusivity period is the time that the seller agrees to effectively take the business off the market so that they can pursue and see if there's a final deal to be made with the buyer. So typically 30 to 60 days, but it might be longer if it's a big deal, if it's a big company, there's a lot to do. Um, Within 30 days, you will know if the parties are serious about moving forward with one another. In most cases, the parties already have a pretty detailed discussion before they're coming to us and incurring any legal fees. So they're pretty serious about moving forward. But again, we identify a number of serious issues in those first conversations that if they cannot get past in 30 days, the deal usually doesn't go forward. But the exclusivity is important for both sides. From the seller standpoint, especially if they've collected some sort of a deposit, they have a bit of a peace of mind that they're on their way out, right? They're close to being done with their business. From the buyer standpoint, they also have that peace of mind. Okay, I've been searching for the business to buy. We're moving forward. And I've had a number of cases, though, where the negotiations have dragged on so long, market conditions change, and one side changes their mind, typically the seller, because they've been approached by someone who maybe gives them a better offer. So, can the seller change their mind during the exclusivity period? If the exclusivity is a binding term, the seller cannot change their mind during that time. Let's say it's 60 days. During the 60 days, the seller cannot renegotiate, cannot sell or try to sell the agency to someone else. And I've had clients take some risk here, right? I've had clients talk to a potential other buyer and say, look, I'm under an NDA, or I'm not interested at the moment. I cannot say why. If they are under an NDA, sometimes they're not even going to be allowed to acknowledge that they are under an LOI and under an exclusivity period. But then there's others who do try to terminate a deal with someone during the exclusivity period. They try to sell the business to another party, and then they get sued because they've breached a binding term under the LOI. And then it gets really expensive. Whatever savings or more money they thought they realized from going with a better offer is now tied up in litigation. So, exclusivity can be extended by mutual agreement if the purpose of the exclusivity is to get through the entire due diligence and close in 90 days. Well, and then you need more, then the parties typically, if they're making their way through the due diligence and things are moving along, it's usually not contentious to extend it. Next slide, please. Okay, let's talk a little bit about the structure of the documents. So at a high level, for LHCSA transactions, and we're not talking about nonprofits here, there's a whole additional layer of regulatory approval for New York State nonprofits. We're talking about for-profit entities, and I've had some solo proprietorships, but typically they're either an LLC or they are a corporation. And so the buyer will be either buying the membership or stock interests of that entity, or they are not buying the entity, they're buying the assets of it. And so let us explain to you the distinctions between those two types of purchases. In home care, because the change of ownership is subject to DOH approval, the closing doesn't happen when the purchase documents are signed. Instead, the purchase agreement is signed at the same time as a consulting agreement and a management agreement. So there are three key documents that are signed at the time of the transaction. The consulting agreement has to be given to New York State. New York State has to be put on notice of this. And because most of these transactions are going to be considered material transactions, there's a new process, a little bit stricter than it was before for notifying the state. The management agreement is also subject to New York State review and approval. And so the management agreement doesn't take effect when it is signed. It takes effect possibly years later, actually, when the DOH approves of it. We've had cases where the change of ownership was approved before a management agreement was approved. That's how long the management agreement approval process can take. However, these additional documents beyond the purchase agreement are necessary. They are, in my mind, and they should be in yours, bridge documents. They allow the buyer, who is not the licensed operator of a licensed business, to come in on day one and operate that licensed entity. The agreements have the licensed operator legally responsible for the entity, and there are all sorts of regulatory points that the buyer has to accede to the seller entity. Seller entity has to stay involved in the operation of the business. And so those management and consulting agreements go through pages and pages of regulatory provision by which the seller maintains operational oversight of the business. And that cannot be forfeited. That cannot be waived. You don't want it to be waived in any way because the DOH could complicate or deny the transfer of ownership. So we always advise clients to just follow the letter of the law to a T when it comes to that period between purchase and change of ownership. Okay. So the structure of the deal, as far as the corporate piece of it, and this part will apply to any state that you go in, whether it's home care or another type of purchase. But asset purchase and stock or membership interests are the two main ones. Okay, if we can go to the next one. I'm going to overly simplify this. I do pride myself on being very plain speaking when I'm describing some of these legal things, but the feedback and the questions sometimes suggest that I could do a better job. So I've tried to really simplify this. So when it's an asset purchase, the buyer is buying specific assets of the business. Contracts, goodwill, equipment, client lists, but they are not buying the legal entity itself. So imagine two houses side by side. They each represent businesses. In one of them is the buyer, and the other one is the seller. In an asset purchase, the buyer is peeling off out of that second seller entity certain things, perhaps the chairs, the office desks, the computers, client lists, policies, procedures. You cannot buy patients and you cannot buy people, right? So those assets, which are truly the key ones in a LHCSA transaction, those ones have to be very carefully stated. There are all sorts of regulators who would have a problem with us saying, I'm buying the people and the patients. The buyer selects which assets and contracts from the seller entity to assume under an asset purchase. Unwanted liabilities generally stay with the seller, and so it is important that in your purchase agreement, you clearly define what liabilities are staying with the seller entities. Buyer gets a relatively fresh start and does not automatically inherit the seller's unknown liabilities, except in home care, because of how the indemnification clause is written, there is a way, even in an asset structure, that those liabilities that were under the control of the seller entity, that those get kept with the seller. The LHCSA license does not automatically transfer as an asset that's being purchased. Again, a little bit of a distinction in other types of transactions. The transfer of the LHCSA from one entity to the next is subject to DOH approval. And then the employees do not automatically transfer. They have to be rehired. They have to be. And so I've seen a number of cases where the personnel file, the job offer is made, and there's no new rehiring. But this is an entirely new EIN that is hiring the people. And so it needs to be a clean slate. Otherwise, all of these steps that you've taken to isolate the labor-related liabilities with the seller entity, they're just going to move over. Because from a common law standpoint, the buyer is going to be seen as a successor of the seller entity. So don't structure it as an asset sale if you're going to try to replicate the entire HR process by moving the file cabinet effectively, to use that analogy. You can't just take the file cabinet and move it over to the buyer entity. You need to create a new file cabinet and put new folders in there. Okay. With asset sale and a corporation, excuse me, a membership interest or a stock in the case of a corporation, we always advise clients to get their accountant involved immediately with an asset sale. There are some allocation IRC rules that could be helpful. But generally with an asset sale, there's less favorable tax treatment for sellers. So always get an accountant involved to see how you can minimize that potential cost. Okay, next slide. Okay, stock membership or interest purchase agreement. Membership interest purchase is for LLCs. A lot of folks are LLCs these days. So contrary to an asset purchase, in a stock sale, imagine an entity, and we here have an oversimplified example. Joe Smith owns 200 shares of common stock in XYZ Corporation, and he sells those shares to Amy Joseph. The entity above those shares remains as is. So XYZ Corp doesn't go anywhere. Remember in the asset sale, we had the two houses. That was the example. That was the buyer and the seller. Here, the seller entity stays what it was. It is only the people in that entity that are changing, the stock owners, the shareholders. And so in this example, if it's one person, Joe Smith, Amy takes Joe Smith's place. Everything else stays the same. The EIN is the same. It's just Amy replacing Joe, and that entity stays as is. Now, this can be a little easier with all of the MLTC contracts. If you're buying an entity, you don't have to change them. You don't have to change the Medicaid number. There is obviously a new license and a change of ownership process that has to happen. But unlike that previous example with the asset purchase, the employees stay with that entity. Their EIN employer stays the same. The downside with stock purchase agreements, and this is just a general corporate matter, slightly different in home care, because the entity stays as is and only the ownership is changing, Amy is stepping into everything that was there. She really has to do a solid job in the contract to insulate herself from the liability that Joe Smith might have caused when he was running XYZ. So with a stock purchase agreement, we're generally a bit more protective of our buyer clients just because the presumption legally is that they're inheriting everything, all the mess that was there when they bought. Okay, I really have to hurry. Next slide, please. Okay, indemnification is a contractual term that is very vigorously negotiated. We've had deals that cannot be resolved because the parties cannot agree on this. This is the line in the sand that basically defines the period of time or the types of liabilities for which the seller will be responsible versus the buyer. The consulting and management agreements will have their own indemnity provisions. and we'll spell out who is responsible for what or when. In a LHCSA deal, the most typical agreement is that the seller is responsible for all liability up and through the date that the parties signed the agreement, whether known or unknown, because a lot of times things will not be known. And we think we build everything correctly, but we won't really know for sure unless OMIC comes in years later, right? And they take a position that we should not have billed for XYZ services because perhaps, oh, the personnel file wasn't up to date or whatever the case is. Or perhaps the in-service schedule is not available. And there's no indication that this particular caregiver who worked with the patient was in service when they provided the care. It could be a number of scenarios that the regulators come in after the fact and seek to hold the buyer responsible for things that happened before the buyer came in. This is where that definition of closing versus signing date is important. What is that line in the sand on the timeline where the buyer is assuming responsibility for things that happened while the previous operator was in charge? So those are heavily negotiated, but what I have just stated is the general agreement. Pending the change of ownership, the record owners of the LHCSA will likely continue to be named and served with any legal documents such as new lawsuits. All right. If all other records, right, the EIN is under the name of the seller entity or the seller owner or owners. And so when someone is looking up in public databases, well, who owns this entity? Who's it registered under? Where do I serve my legal papers? They're coming to the record owner, which is not the one that's operating it maybe day to day. And so it's very important that these indemnification provisions explain what happens with these lawsuits. It could be a slip and fall, as easy as that. And then survival period is the question of how long after a closing may a party bring an indemnification claim. This is separately negotiated. Does it expire? Typically, these survival periods are going to be between 12 and 24 months for general representations, and they could be longer or indefinite when it comes to fraud. If the seller lied and failed to disclose, and yet in the contract they failed to disclose it, they represented that to their knowledge they have never hired any individuals who are, and then they find out later that, oh, wait a minute, this person is an illegal migrant worker. They never completed this class. They never completed this training program, and they billed hours and hours with one of our patients. That's fraud, right? Because the seller knew that they were lying. They lied in the contract. That is an example of fraud that, and that type of a claim doesn't expire. So if the buyer gets in trouble later for having billed Medicaid for these workers, they can go after the seller indefinitely for that type of a claim if the contract says that fraud claims don't expire. Next, please. We might have to have a separate one just for Charlotte, where Charlotte's the only one talking.
This is all important, so it's hard to skip over anything because it's all very important.
Okay. Okay. Escrows, holdbacks, and liability caps. So you could have a provision in the contract where a portion of the purchase price is held back. It's not paid to the seller. It's held back to ensure that if there are these liabilities that come up later, there's money to pay them. You know, a lot of sellers, they retire, they go somewhere else. And then the question that the buyer has is, oh my God, I have $1 million judgment. How am I going to cover this? I don't have $1 million, but someone expects me to pay it. And by the way, it is their liability because this is a claim that arose when they operated the business. This is what the escrow or the holdback will do. And so I always suggest, especially with bigger deals, to have some sort of a holdback amount because you don't want to be in the position of chasing the seller who may have spent their money, who may have died. who might have gone somewhere abroad and you will never see that. So hold some money back. Um, Escrow should be with a legitimate agent, subject to a written agreement, because you do not want to be in a position where you're fighting with the escrow agent saying to say us that I owe you at the clear agreement under which the escrow agent can be directed to release those monies. Um, Very quickly, False Claims Act issues go back potentially 10 years. So just keep in mind if there is a cap on the duration of the liability, some of that may need to be going back 10 years, um, indefinitely for fraud. You may be able to get tail insurance. It could be expensive. Absolutely inquire about that with your insurance broker. Next. Tail insurance is very common with doctors' offices. I see it more rarely in home care. Okay. Real quick, pay time off for accruals and stock transactions. The buyer inherits them. Because the buyer is stepping into the shoes of the individual owners, the entity stays as it is. And these employees have accumulated these benefits with the entity employer. And so those obligations continue to accrue and be the responsibility of the buyer to pay out unless you negotiate something different in the contract. So do not overlook this. I've had cases where this was um, intentionally overlooked, right? And then it blows up later as being something that the parties get close to litigating about. Next page. Same point I made about buyer stepping into the seller's shoes in a stock deal with employee obligations. There could be a number of them. We've identified them here. Go to the next one. Okay. Change of ownership. Given the time, and we have a hard stop at 2, I am going to call it and I'm going to see if I can address any questions. There's a good one that I want to share with everybody about communicating with the MLTCs regarding the clients. Um, I would suggest that there's even a more 101 preliminary question, which is how do you secure those contracts and make sure that if you're doing an asset sale, not a stock deal, how do you make sure that those contracts transfer over? Because remember, the MLTC contract is issued to the entity and under one Medicaid number, under one EIN, the bank account is tied to that entity. The buyer who has a separate entity and is operating the LHCSA under a management agreement until the change of ownership goes through doesn't have those contracts. So how do you know for sure that those contracts will come over to the buyer entity? So that to me is even more of a preliminary question. And then communicating with the MLTC regarding the clients, absolutely. I think it needs to be part of the same conversation. So ideally, by the time the new operator gets approved, you will have established a relationship with the MLTC. You are notifying them at once, hey, we're the new official owners of this LHCSA. It has been great working with you. We will now start transferring the patients over to the new entity, and we're looking for your permission to assume the contract. Most MLTC contracts do have a clause that allows the new entity to assume the contract and the rates and everything, but it is subject to approval, either 30 to 60 days. And so the MLTC has a right to deny it. I have not had that experience yet where they've denied the transfer or the assumption of the contract by the buyer, but it is discretionary. It is up to them to grant or deny that request. So we ran out of time because I talk too much, but I hope this was very helpful to you. Please email us if you have any other questions. I do see some folks here are from nonprofits. We perhaps might have a nonprofit and the regulatory conversation as part of a separate webinar. But like I said at the outset, I thought it was very important to have this conversation. We're doing a lot of these, and folks are jumping into these deals out of entrepreneurial and just desperation to stay in the business, but um, it is absolutely critical that they do so carefully. Thank you so much for tuning in today. I hope this was helpful, and we will talk to you soon.